There's an interesting case there, an interesting decision reported this week to do with, and anyone who has an interest in a commercial lease, a leasehold unit perhaps, would be interested in the outcome of this case. It's to do with Foot Locker. Foot Locker have a very expensive unit on Grafton Street, and they accepted that during the COVID lockdown they only partially paid the rent, and they were arguing basically that the landlord should share some of the pain, in other words the pain of having to close the shop and so on. And this arises from time to time, this question of, was the lease frustrated? In other words, is there an excuse, a sufficient excuse, legal excuse for not paying the rent? So the Court of Appeal has rejected the claim by the operator of Foot Locker that the lease had been partially frustrated as a result of having to close due to the pandemic lockdowns. In December 21, the High Court rejected the claim by the footwear and clothing store that it had liability for only part of the 2020 rent due to some 253 days of pandemic-ordered closures. The landlord naturally argued that there was no basis for such a claim and sought payment of the full rent. And the High Court found the concept of partial frustration of a lease was not one which exists in Irish law. It may exist in American law, but it doesn't exist in Irish law. The Court of Appeal was asked then to look at this case again. In its action, though, Foot Locker accepted that the rent had only partly been paid for the lockdown days, but said that the landlord should share some of the pain caused by the closures from the COVID-19 pandemic. The landlord contended that partial frustration of a lease was unknown in law or known not to exist. In other words, they're arguing that the decided case is that the accepted position in Irish law is that the partial frustration of a lease does not exist. It argued that the lease had not, on the facts, been frustrated in any way, and it also counterclaimed against Foot Locker. The High Court, as well as rejecting the Foot Locker case, also granted the landlord judgment for rent arrears of just over €1 million. Foot Locker appealed. That was a High Court case. Foot Locker appealed, claiming the High Court had erred in its decision on several grounds. The landlord naturally opposed the appeal. The Court of Appeal then last week found that the High Court had identified and applied the correct legal principles and had reached the correct conclusion. The court said that he entirely agreed with the High Court judge that there does not exist, as a matter of Irish law, a concept of partial or temporary frustration of the lease as contended for by Foot Locker. Such a concept, the judge said, is contrary to principle and authority. As a matter of principle, it was impossible to see how a contract could be frustrated for a period and then revived or resurrected when that period was over, he said. That's an interesting legal principle, as it were. That was conceptually impossible as a matter of principle and, in the words of the High Court judge, does violence to the fundamentals of the doctrine of frustration, he said. It was also entirely contrary to well-founded authority in Ireland, including decisions of a number of High Court judges and case law from other jurisdictions, he said. He said he was also declining Foot Locker's invitation to the court to make new law in this area. So Foot Locker accepted that the law heretofore was against them, but the Court of Appeal was being invited to make new law. The Court of Appeal declined. So the bottom line is, if you have a shop, if you have a leasehold premises, you might have an office, you might have some other premises, a warehouse or a shop or whatever, a commercial unit of some description, then you may try to argue at some point or other that the lease has been frustrated by some event or other, and it seems to be the case that frustration or partial frustration of a lease cannot occur. Perhaps a full frustration or frustration of a lease simpliciter can occur, but a partial frustration cannot occur. For example, the argument that during COVID-19, for a certain period of time, commercial premises had to close and therefore the lease was partially frustrated. It wasn't. business owner was frustrated, all right, absolutely. But the lease wasn't frustrated. The lease was still in existence. And unfortunately, the COVID-19 situation made it very, very difficult for retailers. But Foot Locker is the latest one to find out that the partial lease or partial frustration of a lease in Irish law is known not to exist. Hope you find this video useful. If you do, I'd appreciate if you gave it a thumbs up down below. And you may be interested in checking out my podcast on Spotify or iTunes. It's called the Irish Law and Small Business Podcast. Thanks a lot.